When there's an escape of water claim, obviously customers have various options depending on who their insurer is. So normally the insurer will either appoint one of their own repair firms to fix the damage, or the customer can submit their own invoices to assess what the cost would be for them to do it themselves.
And this policyholder knew exactly what he wanted.
The claimant was pushing for a cash settlement of £15,000. On the surface, the claim seemed absolutely fine because an incident had happened. There was no reason to not cash settle because, in essence, a genuine invoice had been presented to them.
But something had caught Tara's attention.
There was what I call a behavioural red flag where the customer was complaining and he was very aggressive directly with the insurance company because he was constantly pushing for the cash settlement to happen quicker.
It was time for Tara to speak to the claimant, and she had one clear goal.
The aim and objective being quite simple, it's a search for the truth.
Tara's training would be critical to getting honest answers.
Tara Shelton from ICOG, how are you doing?
Yeah, not a problem. Very good, thank you.
My role today is to do the right thing, and hopefully you will too.
Yeah.
Have you made a genuine claim?
Yes. So I got videos on my phone where they asked me to video the water leaking down through the ceiling into the living room.
Okay. I need to make you aware of a few things.
Yes.
The insurance company had already received some anonymous tip-offs with vital information.
The phone calls were actually from 3 completely different people, and they were members of the community who felt very strongly. The information within the call recordings was quite clear that this individual had been in the local village, pub, shops, etc., and was, if you like, bragging and boasting that he was wishing to defraud the insurer. It's my duty to share with them what our findings are and certainly hope that he's human enough to be honest and tell the truth.
Your insurance company has received 3 anonymous phone calls about you.
Yep.
This first call was received on the 18th of July, a day after the verbal agreement to offer you a cash settlement. This individual knows that he is your insurance company,
Right, okay.
knows you very well, and said that you're making a fraudulent claim.
I think that person is wrong, I think.
Okay, well, let's go through it. They said that he's flaunting around the pub, that he's getting thousands, as he's getting the work done much cheaper. He's telling people at the pub he'll make £9,000 cash and get the rest of the house done up.
At the end of the day, I've got a leak in the house. I'm not hiding the thing.
You can make a judgment on this call. I can't help you after this phone call.
Tara had put her cards on the table.
I think that person is wrong.
Well, I don't believe you, and I have to explain why. There's no way a court in the UK would believe that a person would make an accusation against you with information that only you could know. And part of that information is the value of the claim.
Yeah, of course, yeah.
It was at this point Tara revealed the ace up her sleeve.
So the second call, they say that they know that the quote that you received was for around the 14,000 mark, but you're wanting it done for about £3,000, and that's what he's going around telling everyone.
Well, I haven't said that, honestly.
So the third call
Yes.
received was on the 23rd of July. Someone I know is insured with you. He's getting the whole house done on you, as works are much cheaper with kind of the new person that you'd appointed to fix it. He then said he's absolutely disgusted with you and what you're doing.
3 independent accusations. Would this be enough for the claimant to concede defeat?
Somebody just got it in for me, I think, and I'm going to have to take it on the chin, aren't I? You know,
Be honest with me here, because once this call is finished, you could get arrested.
Right,
So I need you to be man enough to make this problem go away and do the right thing.
Of course, yeah. You know, I just want my house back to where it was before I had the leak.
These 3 people
Yeah.
would actually be willing to stand up in court and tell them on oath what you've said.
Yeah.
Okay.
Yeah, fair enough, that's fair enough.
The claimant still wasn't fazed. But Tara had even more evidence. This time, a text message that had been sent to the original builder who had provided a quote for the work, telling him his services were no longer required. This message had been sent just over a month after the claimant decided on a cash settlement.
So you've lied saying the insurance company are doing it, but that's not the case.
Right.
That's a lie.
Yeah.
It was starting to unravel. So Tara explained the potential consequences of pursuing an exaggerated claim.
I would literally screen through every phone bill you've got and identify who that new supplier for the $3,000 work would be. I would go to people in the pub and the village and get court-compliant statements from them. You would then potentially, if you got a criminal record, lose your job.
I would, yes, yeah.
And he would be put on the fraud register.
What will happen is you won't be able to get insurance for your car, your house, anything.
Anything, yeah. Go to life insurance and, yeah.
So you understand that?
I understand that, yeah.
He had such a good working relationship with me on the phone that he trusted me enough to make the right decision of what to do.
Well, obviously, these people who's coming in and doing the work now is doing it cheaper. I can't deny that. I wasn't going to make £10,000 out of it.
So what were you roughly looking to make?
Probably somewhere around about £500.
Okay.
Obviously, I was going to do my bathroom out of that then. Because obviously, I need a new bar and toilet.
Okay.
I'm going to treat myself to a spa bar.
Okay. Thank you for being honest.
As you say, I didn't think I'd be in this position.
I think this was just a genuine person who, when he saw that invoice, became exceptionally greedy and had no concept of what he was doing in the initial stages. The claim was declined, invoking the fraud condition, and the policy was voided as if it never existed. Now, that customer, for the rest of his life, has a legal obligation to disclose that he had a claim declined for fraud.
His actions could have resulted in prosecution and potentially a criminal record.
I think he had the fright of his life that day. I would be highly, highly surprised if he would even risk doing that again.
Mr. Shabangu presented a personal injury claim. He alleges that he fell off his push bike as a result of a paving defect. The front wheel of his bicycle went into some of the holes where the bricks were missing on the paving, and the back wheel come off of the ground, and he had to take his feet off the pedals to put out onto the floor to support himself. And when his right foot hit the floor, it landed in a twisting motion, which caused him to break his ankle. The injury was quite serious. He'd suffered a significant break to his right ankle, which required pins and metal work in there to help kind of rebuild it and support his ankle going forward.
And Mr. Shabangu wanted Cardiff Council to foot the bill.
So the claim was worth £175,000. This is broken down of legal costs, medical costs, his inability to work, and compensation for the injuries he sustained.
It was not looking good, and he firmly laid the blame at Cardiff Council's doorstep.
Councils have an obligation to ensure that all the highways are kept up to a reasonable standard and have a series of inspections in order to ensure that that's the case. In this case, Cardiff had noticed that the defect was there that Mr. Shabangu alleged that he'd fallen in, and rectified it soon after this alleged incident had taken place.
The pavement may have been fixed, but Mr. Shabangu had gathered evidence before this happened.
He presented some photographs of a defect that he alleged caused the incident. This was some brick paving along Atlantic Wharf where some of the bricks had come away and also had moved up and were kind of out of shape.
The photos supported his allegation, and of course Mr. Shabangu had a badly broken ankle as physical proof.
There was nothing that we'd established that went to suggest that there was anything untoward. The injuries that he sustained were genuine. His hospital records and medical records showed that he had actually suffered an injury.
Further investigation led Aidan to two passers-by who had seen Mr. Shabangu take a tumble and had gone to assist him.
So a couple who witnessed the incident had called an ambulance, stayed with him until the ambulance arrived. Our own lines of inquiry meant that we gathered a 999 call, which you could hear the witnesses who were helping Mr. Shabangu say where the incident took place.
Hello, I want an ambulance.
Yeah, what's the full
Want an
address of
ambulance.
the emergency, please?
Please go in way.
And where's that to?
CSN 4JF. I just had the guy just tell 1 month.
Confirm the full address again to make sure we got it right.
Galleon Way, CSN 4JF.
But Mr. Shabangu had said the incident took place on Atlantic Wharf, which was around a 10-minute walk from Galleon Way.
There were very obvious discrepancies between the two different versions of events.
And the location wasn't the only difference.
When did this happen?
Just now.
Okay, and what caused the fall?
The floor was slippery. He was riding his bike and it's kind of slippery.
No mention of loose pavement slabs, and the paramedic report also confirmed the different address.
It is impossible that Mr. Shabangu could have had this incident at Atlantic Wharf. The incident took place at Galleon Way.
The whole claim was now on very uneven ground, and Aidan had one more card to play.
He presented a loss of earnings claim as a result of having to change his role from a barman and a cleaner to becoming a security guard. He said that his new role as a security guard would mean he'd spend less time on his feet, so he'd be more capable of doing that role.
But when Mr. Shabangu's wage slips from before and after the accident were compared, they just didn't add up. So Aidan got in touch with the tax office to see if he could flush out the truth.
He was actually earning more as a security guard than he was as a barman or a cleaner. And ultimately, you can't present a loss of earnings claim for a personal injury case if you haven't suffered a loss of earnings. We provided Mr. Shabangu's solicitors with a transcript of the 999 call, the ambulance report we'd received from the paramedics, our concerns around the exaggeration of his claim, and also the kind of misrepresentation of his loss of earnings. Collectively, that meant that they decided to drop him as a client.
But far from stepping down,
Mr. Shabangu sought to represent himself for the next 2 weeks. I was shocked that he continued to present the claim. He was without legal representation and he knew he was lying. I think he'd wrapped himself up in so many lies and he'd committed so much to this fraudulent claim that ultimately he still thought he could probably get it over the line on his own, but he just simply couldn't and filed a discontinuance with the court.
£175,000 was not coming his way. But something else was.
Councils will compensate genuine claimants for genuine injuries. If they're presented with fraudulent claims, they'll do everything in their power to ensure that they're brought to justice. And Travellers Insurance take a robust stance to fraud. We referred this matter to the police because the fraud was so blatant in this case and of such high value that we believed that a prosecution was necessary, and also to support our customer, Cardiff Council.
Mr. Shabangu was called in for questioning.
Subsequent to that interview, they provided all their evidence to the Crown Prosecution Service and he was sent to court for a charge of fraud by false representation.
Having been charged, he was now due at court, but there was another surprise in store.
He pleaded not guilty at trial. The evidence against him was overwhelming and he offered no defence of any kind.
Whereas the police had gathered compelling proof he had been lying.
So ambulances have a black box system similar to aircraft that record data such as GPS tracking and the speed of the ambulance. The GPS tracking data supported the 999 call and the ambulance report by showing the ambulance's destination after it had been called.
And the destination? Galleon Way.
He was found unanimously by the jury to be guilty. It took them 20 minutes to come to this verdict. It was a really short period of time, and the judge handed him down a sentence of 3 years, 6 months. I've been a fraud investigator for 10 years, and I've never seen a sentence handed down of such significance for a single act of fraud.
A victory for the city of Cardiff and for travellers.
I'm pleased with the outcome of this case. Insurance fraud is not a victimless crime regardless of who it's committed against. Mr. Shabangu has attempted to take money from Cardiff Council unsuccessfully, and this is money out of the public purse. I've never seen a sentence handed down as harsh as this, and it's ironic that Mr. Shabangu worked in a casino because he's taken a gamble on this case and it's not paid off for him.
So this matter relates to a watch that was left on holiday by our policyholder. He alleged that he forgot to pack the item and then returned home without it. The watch on this particular occasion was worth £3,800.
Making his weekend caravan break a very expensive one.
And funds kicked down when the incident happened you're looking to claim for?
Well, it's this weekend we've been on holiday and we've come back to not at my watch. I've rung this site and they're now saying they can't find it and the caravan was stopped in.
You know what date that was?
Last time I can recall seeing it was Sunday when I wore it on the 19th.
You reported it to the local police?
No, I didn't even think to call the local police. I just contacted the site, that's all.
Okay. In terms of any say potential claims for any lost items, we do require that they are reported to the police, so it would require some form of reference.
Right, yeah.
And you said it was for the Omega watch you have on the policy.
The Omega seen last year.
If you can please forward on any proof of purchase you may have, or take photos of yourself with the watch and anything like that for us as well, just to help validate the claim on our end.
As part of our investigation, he was able to provide us with a copy of the purchase receipt, the box, confirmation of his holiday trip, as well as the police report.
Having received the necessary documents, LV also got its investigator to put in a call to verify some facts.
So when you went away on this holiday, what watch were you wearing when you went away?
The watch I was wearing was my Omega.
So it was the only watch you took, or did you take any other watch?
It's the only one I took with it.
So when you went on holiday then, to the caravan, where was the watch located most of the time?
Well, I got it on the wrist when I got there. I took it off whilst I was there, and then I kept putting it back on like on a night.
If you were wearing the watch when you went away, why wouldn't you continue wearing it when you return home?
I got to put everything away, got the kid to sort out and everything, so that was the last thing I thought about putting it on.
And when you were packing up to go, where did you think the watch was?
I'd have left it on the side next to the bed we were sleeping. That's where I used to put it when we were there.
How would you have managed to have missed it when you were leaving?
Well, I'm not sure, like my wife packed up, but also I've got a little girl that's only 2 what we're in out of the bedroom, so I don't know if she could have knocked it off the side.
And when did you find it was not there?
Monday afternoon, once we got back and sorted everything out.
Did you contact the police?
I contacted them again Monday afternoon.
I think that's all I needed from you. Thank you very much for your time there.
Based on our investigation and the evidence that had been provided, we had no reason to disbelieve this was nothing but a genuine claim and proceeded to pay in full.
So the claim was paid, but not before the details of the watch were entered into a worldwide database for lost and stolen watches. Case closed? Not quite, because some months later, LV received a call to say the watch had turned up at a jewellery shop.
Following purchasing the watch, the jeweller carried out a series of checks. One of those checks included checking the central register, where he identified that the watch had been subject to a claim with LV. When contacting LV to make us aware that they had this watch in their custody, they made reference to the fact that they'd been presented with ID documents for the person selling the watch.
This mystery person could have been someone who'd found the watch, or potentially the person who'd taken it in the first place.
Lo and behold, that turned out to be our policyholder.
That's right, it was the claimant himself who had sold the watch to the jewellers.
Following receipt of this information, we contacted our policyholder to challenge him in relation to this new information. The excuse for him having the watch back in his possession was it had turned up at home.
It'll come as no surprise that this was an explanation LV wasn't prepared to accept.
In that conversation, he did offer to pay us back in full for the value of the claim.
Despite the claimant's promises, LV was left waiting and never received a penny. But if the claimant thought burying his head in the sand would make this go away, then he was sorely mistaken.
So we passed our file of papers to our lawyers, who wrote to the policyholder, and he has since paid us back in full.
The customer contacted our claims department to make a claim for a lost GoPro camera which went missing on a holiday to Uganda. The customer told us that while she was kayaking, the GoPro camera which was attached to her protective helmet fell off. The value of this claim was £390. The circumstances of the incident were entirely plausible, and initially we had no reason to disbelieve the customer.
How can I help? I was on holidays recently in Africa and I managed to lose my GoPro on my head when I was kayaking. I was just wondering, I don't know whether or not I'd be able to claim for it on my holiday insurance.
It's certainly something that we can look into for you. You said the GoPro was attached to your head when you were kayaking.
Yeah, so basically, the GoPro is attached to a helmet on a mount, and I went over and I hit a rock which dislodged the mount from my helmet, so the GoPro then sank.
Okay.
Just got it for Christmas.
Oh no. So I'll get this claims information pack sent out to you. It will ask you a few questions about the insurance, which I will go through with you now.
Whilst taking the initial call, the claims advisor was also doing some checks.
We did a previous claim search and could see that the customer had in fact made a claim previously just 3 days before.
So at this point, Seeger needed to ask more questions about policies.
Do you have any other travel insurance?
No.
Okay, and have you pursued a claim for this through any other insurance?
No.
So what I can actually do for you is I can get this forwarded across to my claims validation team, and someone there will be in contact with you.
Okay, thank you.
At that point, we didn't disclose to the customer exactly what we knew. It is entirely plausible that the customer may have owned 2 GoPro cameras, but it was clear we'd need to have a chat with her to find out whether that was the case.
But before doing this, Seeger called up all the files.
After reviewing the detail of the previous claim, the location of the incident was exactly the same, the item she was claiming for was the same, and the date of the loss was also the same. It was clear that the customer was in fact making the same claim.
It was time for the validation team to dive in and confront this double accounting.
We just wanted to have a quick chat with you regarding what's happened. I'm aware that it's your GoPro camera that's been lost in Uganda, is that right?
Yeah.
Okay. Can you just tell me what actually happened in that incident, please?
I was kayaking down the River Nile. I capsized. I hit my head off a rock, and then the camera sank.
Okay, I understand. And were there any other incidents during the trip where any other personal possessions went missing at all?
No.
Okay, that's fine. In relation to your current policy, and I'm aware that it's like a pack policy, a travel pack that comes with a sort of added benefits. What benefits was it that you were under the impression that the account had when you took it out?
And claiming for something twice would not be the right answer.
Breakdown cover and travel insurance.
Okay, so you were aware of the travel insurance at the time?
Yeah.
Okay, that's fine. Do you hold any other policies that will cover this incident, or have you claimed, or are you claiming this anywhere else?
No.
Okay. So within the insurance industry, insurers share data in order to detect and prevent fraudulent claims and to detect or prevent crime. Now, just in relation to your claim, we've actually been made aware by another insurer that you've actually made a claim with them for the same incident. Can I ask for your comments on that, please?
Yeah, I have another one as well. I had 2 GoPros.
Okay, so what happened in that incident?
There was a similar situation where I was swimming and it came off my head.
Okay, because I asked you earlier in the call whether there were any other instances of loss during the trip, and you said there weren't, and confirmed it was only the one GoPro that went missing?
At this point, she seemed to be up the creek without a paddle.
Oh, sorry.
Okay, so also, because we've shared information with the other insurer, we've actually been able to get a copy of their file. And when you registered the claim with them, you were asked if you had any other insurance, and you said that you hadn't.
Okay.
I'm just trying to understand why you would have told them that if you were aware of this policy.
I don't know, because I suppose I wasn't sure if my insurance would come through.
Okay, but why wouldn't you tell them about it if they'd asked?
I suppose I forgot.
For us, this was not a reasonable explanation because she had already been through the claims process just 3 days before, and a £390 payment had already been issued.
Her chances of successfully claiming for the same gadget twice were sinking fast.
I'll give you the opportunity to be open and honest with me. It certainly appears that you've claimed for the same item twice. It is better to be honest with me at this point. Is that the case?
Yes, sorry.
We won't be paying any part of your claim. I will be writing to you outlining our position within 5 working days. We'll also need to make your other insurer aware of what's happened as well.
Okay.
Thanks so much for your time today.
Okay, thank you.
Bye.
On this occasion, I think the customer just got a bit greedy when she realised that she had 2 insurance policies that possibly could pay her out for the same claim.
And maybe she thought £390 was small fry.
SIGA have a zero-tolerance approach to fraud, regardless of the value of the claim. We then referred the matter through to our client, the underwriter of the insurance policy, who decided to refer the matter on to the police. We later found out that the police did take formal action against the customer because she accepted a police caution for fraud by false representation.
Horwich Farrelly is a specialist law firm that represents insurance companies and is well versed in dealing with cases involving claims management companies. This next case demonstrates the lengths that some of them will go to.
We were instructed to investigate a very minor incident in which a claim had been brought following an accident that happened in a car park by a mother and her daughter.
Their car and a transit van had collided, resulting in injuries to both women.
The claimants didn't receive any medical treatment, but were examined by a medical professional who was instructed by their solicitors. The medical report said that both claimants had sustained whiplash injuries lasting between 6 and 9 months.
The fact that the women were claiming to have been in pain for so long, despite the minor nature of the collision, raised some questions.
We were instructed to investigate the claims because there was a dispute over whether or not the claimants were genuinely injured. It went through our intelligence team, who carried out investigations into the claimant, which included looking on Facebook.
On the day of the accident, there had been a post. In addition to this,
during the time that she said she was injured, she was actually doing various activities.
And it wasn't attending a book club or a genteel art class. David passed on the findings to her solicitors.
And they decided that they could no longer represent the claimants and came off the court record.
Horwich Farrelly wrote to the claimant to inform her of her predicament. However, her response was the last thing they were expecting.
She contacted us to say that she'd been harassed over a long period of time and was eventually persuaded to bring the claim by a claims management company. The company had promised her that there was a pot of money waiting for her, that her claim wouldn't be challenged, that it'd be straightforward, and all she had to do was submit the claim to the insurance company.
It had started as a cold call, but had soon escalated into being harassed for many months. And when there was a family tragedy and she was most vulnerable, she gave in and submitted a claim for injuries she didn't have.
When we were told the name of the claims management company, our intelligence team searched that against other cases that had been presented against our insurer client and discovered that we had in fact come across them before.
3 years earlier, whilst trading under a different name, the same company had been representing a mother and her 3 children for whiplash injuries. On that occasion, Horwich Farrelly had been called in for exactly the same reasons as it was now.
We were instructed on the basis that this was a very minor incident and that injury was very unlikely.
And that previous investigation had resulted in the discovery of a very interesting phone call recording.
Between the claimant's partner and our insurer client, but unusually, also on the call was the same claims management company.
I know the accident date you're looking for.
The date of the accident, yeah, please.
The accident date?
Yes. Hello?
Yes.
Hello, hi, sorry mate, we're the solicitors who are dealing with your client. Sorry, our client lost his documentation. My client's after the accident date.
And what are you dealing for our client?
Sorry?
What are you dealing for our client?
Sorry, is that any of your concern?
To have someone from the claims management company as a third party on the call was far from common.
Typically, when accidents are reported, there wouldn't normally be a claims management company involved at that stage.
If you want to give us authorization, yes, I'm giving authorization, yes.
And yes, how may I help you?
Yes, well, just after the claim reference number for, well, first of all, the date of the incident, where under it was. You said it was a taxi, wasn't it? Reversed into the back of your car, yeah.
It was, I don't know the name of the street, I think it's Boston Street.
Okay, yeah. Have you located it? It was 2012, I believe. Have you located the incident?
Right, the accident date is 22nd of November, 11.
Yeah. Oh, 11. All right, you're a star. Thank you.
After the initial details were provided, the conversation continued after that between the claims management company and the claimant's partner.
Insurance companies record all of their phone calls, and what happened in this case is that the call continued to record after the claims management company and the policyholder thought they'd hung up. What was said was very revealing.
Oh my word, but that's it now. We've got everything. As I said before, I don't want to raise your hopes too high, all right? Because you didn't go to the hospital. It's just, right, what they do is they'll set money aside and set us, because you got hit from the back, they assume you would have had either minor neck or shoulder or back discomfort.
Can I be honest with you? There's one thing.
Of course, yeah.
I did try to make a claim in for whiplash for that, and I heard nothing back off them.
Right, so you're already making a claim.
Well, you know, we're going back out since I was in well, and I still haven't heard anything. So they've forgotten about it.
Yeah, I did.
I didn't say anything, you see.
You didn't sign anything?
No.
Oh, then that's fine. You just spoke to them.
I just spoke to them, and they said they would get back to me, but I haven't heard.
I'll give you a tip with how claims work, right? Even if you just put down a file that you had minor discomfort in your shoulder, you're going to get paid out. The more parts of your body that you had in discomfort, the more money you'll get.
Yeah.
All right? So where should I put down that everybody had their discomforts?
It was in the neck and shoulder.
That's fine. That should work out a decent payout. Now, what's going to happen now is, I'll put you through to the solicitor. These are our solicitors. All right? If you don't get paid, they don't get paid. If you don't get paid out, they don't get paid. Nobody's ever going to try to prove or disprove what you said. It's never going to go to court. And at no point do you ever dip your hand into your pocket to pay a penny. And you will never divulge your bank details. When you get paid out, you get paid out via check in the post. That's how it works.
One of the concerning parts of that call was the fact that the claims management company told the claimant's partner how to present the claim and how to maximise their compensation as well.
But now these same cold callers were back on the scene and still coercing people into making bogus claims. So David's team conducted further searches.
We discovered through cold calling forums that this company had actually been involved in similar practices on numerous occasions, and there were lots of reports of aggressive cold calling and promising people pots of money with no strings attached.
Advertising 0 penalties for making a claim was an entire work of fiction.
Despite saying that the claims management company was the only reason she actually brought the claim in the first place, she had still decided to go ahead with what was a dishonest claim. So the consequences of that was that the claimant had to repay the insurer's costs of around £4,200.
Having discovered that the company was still up to its old tricks, David escalated the case further up the chain.
Once we'd completed our investigations, we presented all of our evidence to the claims management regulator, and they then subsequently investigated the claims management company. The claims management regulator then contacted us to confirm that the claims management company had surrendered its authorisation and can no longer practice as a claims management company. This has meant that this company can no longer persuade people to bring claims.
That's one claims management company that won't be preying on anyone else. But the problem is still there, and what we all need to be aware of is that by pursuing claims we aren't entitled to, we're the ones who can end up out of pocket, and in some cases, with a criminal record.
Whilst unethical, claims management companies will face the consequences from the claims management regulator, claimants also need to understand that where they present dishonest claims, they will also have to pay the costs.